Dads, did you know that a single sheet of paper can bar you from your own kids before you've even had a hearing? Scott Boat's here, Texas trial lawyer and father-first fighter. Today we're exposing the hidden weapon called the protective order, where judges too often enter the fight as dad's secondary opponent. In most states, mom or anyone can ask a judge for a protective order by claiming family violence or fear. The general legal threshold is clear and present danger, but the hearings are often ex parte. You're not in the room to defend yourself, and mom has free rein to cry, emote, and dramatize, all in your absence. Ex parte literally means that only one side tells the story and, in my opinion, seizes the opportunity to bias the judge through a member of the local legal community known and trusted by the judge. Obviously, that's not fair. Recently, the podcaster Joe Rogan was appropriately protected against obvious threats from a clearly troubled third party. But that's not what I'm talking about. I'm talking specifically about divorce cases where one party, typically the wife, uses an altercation, whether real or staged, as the basis for a claim of assault, then couples the criminal charge with an ex parte protective order, and too often succeeds in kicking the husband out of his home and potentially away from the kids for weeks, months, and even years. In other words, the basis for a criminal complaint is recycled into dramatic testimony seeking an ex parte protective order, leading to a hearing before any temporary orders are issued in the divorce, and putting husbands of dads hopelessly behind and financially broken in the pending divorce and criminal litigation. Now, I appreciate that this is a sensitive topic for many people, who tend to be hypersensitive anyway. Maybe you should turn off this video and get back to your shows, your Facebook feed, and your cat videos. Let's get real about most family law protective orders. No, we're not talking about OJ and Nicole Brown Simpson. Instead, we're talking about normal, working men and loving dads who are denied a jury, denied the opportunity to develop any defense, let alone a real case, because a judge sides with an applicant in the ex parte hearing and is then asked to second-guess herself in the full-blown hearing. But since the man is also facing criminal charges, how can he be expected to possibly incriminate himself with testimony on the ex parte protective order? He's stuck. His testimony is inevitably limited. Too often, the husband, the dad, the man cannot come back from the judge's initial bias and cannot present a complete defense. The time to prepare just isn't there, and the judge is hyper-concerned with the drama, not the process, in my opinion. Worse, the same judge who granted the ex parte order and threw the man's life into chaos, then also hears temporary orders in the divorce, then the divorce, and incredibly, even the underlying criminal case depending on the size of the county. That arrangement is utterly unfair and indefensible. The judge sees the man guilty by association with the repeated and rehashed allegations made again and again against him. You can't reasonably expect that the judge who granted the ex parte order then granted a 2-year protective order, then heard temporary orders and the divorce itself will somehow forget all of that as she rules over the criminal assault charge. That's absurd. The process is absurd and predatory against husbands, dads, and men. Clearly, the system works only for itself. The judge won't treat the local politician or local millionaires the same as the regular guy who works at a plant or in a school or in retail. I'd love to say that a recusal of the judge who granted the ex parte order is possible, but that's rare. That case is taken to a regional presiding judge, who sees everything from the lawyer and judge class, as if the law is rational and the motives of elected judges are always pure. Regardless, a man can easily be ruined and financially broken through the protective order circus, and he finds the judge as his most powerful opponent. But that's what the law allows. And the pro-mom and women do no wrong sycophants in popular media ignore the protective order cancer. Still, once a protective order is signed, that order can evict you from your home, block every call, and set the stage for the temporary orders that shape final custody, child support, and spousal maintenance, especially since the man is suddenly guilty of family violence, an important standard in Texas for awarding spousal maintenance. Dad can lose access for 90 days or more. Unwittingly, Texas judges are inadvertent Marxists, hell-bent on the destruction of families through the erasure of dads. A former judge in Houston was notorious for granting lifetime protective orders until she thankfully lost her primary in 2022. But electoral politics is rarely effective in weeding out the bad judges who anonymously ride electoral waves every 4 years. Meanwhile, what's the child expected to believe about dad once the judge inks the order, other than what mommy instructs? Daddy abandoned us. Here are 3 real-life stories I've recently collected about protective orders. First story. Gerald, a vet with 0 criminal history. He was hit with a 2-year order after criminal assault charges filed by the wife, right after she filed for divorce, cleaned out their bank accounts, and hired the judge's former law partner to represent her in Psycho County, Texas. Of course, the judge gave her colleague the order, and then Gerald was incarcerated for violating the protective order. When his divorce trial came along, he was denied access to the trial because he says the judge claimed Gerald had failed to file his own request for a bench warrant. So Gerald defaulted. Gerald had no counsel because he was denied access to marital funds, and you don't get a lawyer appointed on such civil matters. Perhaps from the court's view, as affirmed by the trusted member of the local Psycho County bar, Gerald was simply violent and better off in jail without access to his kids, his property, or assistance of counsel. Predictably, Gerald lost his interest in a $500,000 marital estate. Truthfully, Gerald lost everything. And after the divorce, that assault charge, which was the basis of the protective order, it was dismissed. Perhaps the choreography didn't stick, or maybe it just didn't matter anymore. Regardless, this all happened to Gerald 9 years ago. But since he has a traumatic brain injury arising from an accident, he was lost in the process. Intermittently, he has memories and seeks help. He contacted me on June 27th of this year. Worse, I believe every word of his story. It rings true, and not just for that particular county. There's a Gerald in every county, everywhere. Second story. I'm told that Ricardo is a great dad to 3 kids, all under the age of 8. But his wife got an ex parte protective order right after cleaning out their $30,000 savings account. This happened in a medium-sized county. His lawyer didn't want the associate judge who granted the ex parte order to rule at the hearing, so he was offered this deal. Ricardo can have the hearing before the elected state district court judge, but he has to wait 4 weeks because the judge is in the middle of a capital murder trial and very busy. So, Ricardo was told to stay out of the house, in a hotel, without access to his kids, his property, and his life. But the district judge sure will get to that protective order hearing muy pronto, but still needs his associate judge, who granted that ex parte order, to rule on the temporary orders in the divorce, which will certainly only deepen Ricardo's financial hole. Third story. LaDamian was living in South Carolina with his 4-year-old daughter when his baby's mama showed up with cops to collect the child. Mom had abandoned the child a year earlier, but now she explains to the South Carolina cops that she's not really sure that LaDamian is the father at all, and there's certainly no paperwork saying so. He's not on the birth certificate. Amazingly, LaDamian's child now has an unknown father, primarily because our culture coddles women and permits the choice of making children fatherless. Regardless, Mom got the kid, and LaDamian followed them to the Texas Hill Country, where he was able to visit the child in the extended stay hotel where the mom lives. LaDamian agreed to pay the mom regular support in exchange for time with his daughter. That was helpful, since Mom doesn't work and lives off public welfare benefits. But then, alas, LaDamian made the mistake of getting a girlfriend. So, you know the rest of the story, probably better than most judges who are just so very busy being busy. Again, there was a staged event, then there was the ex parte protective order, then there was a hearing where Mom was represented by a county attorney at no cost, and LaDamian had no lawyer at all. Can you predict the outcome? Yes, you can. And so it goes. The factory churned out another protective order and alienated another child from the only parent she ever knew. Way to go, county attorney. Way to go, judge. System 1. Humans 0. The point is that protective orders alienate dads because courts presume danger. Judges play it safe. Better to be wrong than sorry, while dad bleeds time, money, and reputation. So dads, you can fight back with 4 moves. Move number 1. Silence is a superpower. No angry texts. Mom's using everything you do and say as part of her choreographed story. Move number 2. Document everything. Screens, GPS, witnesses. Move number 3. Demand a hearing that actually allows due process and do all that's possible to appear with a lawyer. Move number 4. File for counter relief. Join the protective order lawsuit with a custody lawsuit. Look, you're fighting uphill anyway. You don't make friends by limiting your counterattack, and a custody suit matters in modifying the protective order after you've been railroaded. So, balls out, gentlemen. Attack. Look, I know that real violence deserves real protection. Everybody already knows that. But rubber stamp orders weaponize fear and erode fatherhood. We live in a culture where everything is feigned, exaggerated, and downright fake. Courts are about process and proof, not relationships between the bench and the bar. Yes, we can protect victims and preserve parents' rights, if courts honor evidence over emotion. With all due respect, stop the virtue signaling, Your Honor. You can't be a real judge without having once been a lawyer. Think and act like a lawyer, not a social worker or grief counselor. We need due process and equal protection, not choreography, drama, and crocodile tears. Can the applicant at least bring her own tissues? What's she really crying about anyway? Is that normal? Judge, do you really think the kid will be safe around that and learn to be strong, independent, and capable? I think the crying mommy will raise an anxious, depressed, and angry kid, and I'm right. So maybe use the protective order hearing to tell mommy to get some help while dad raises an independent, strong, and capable kid. Or maybe your Marxism isn't all that inadvertent after all. More seriously, my mission is to end the cultural coup against fatherhood. If you've been blindsided by a protective order, let's schedule a strategy session. I don't charge for the call, and I absolutely want to hear your stories about the jobs Texas family courts do in serving their constituency. Family law protective orders are too often bullshit. Let's fix that by telling your story. And I want to do what I can to help courts recognize that you are part of their constituency too. So, tell me your story. I care. Send me your documents. I'll give you 33 years of courtroom fire in return. Remember this, Dad. Family courts can sign paper, but they can't sign away your purpose. Let's reclaim it. Together. When Dad saves his kid, he saves the culture. Boats Law. I hear you, brother. Call 713-664-4010 or email scott@boatslaw.com. Reach out and I'll do what I can. One dad to another.